Vallow Daybell has done a lot of objectionable things in her life. For one, she murdered 2 of her kids. For 2, she murdered the wife of the guy that she wanted to marry, and then she did marry him just weeks later. For 3, she may have murdered her 4th husband to make way for that last marriage. And trust me, there are so many other things, which I will get to in a moment. But that 4th husband, Charles Vallow, that is why she is currently in an Arizona courtroom, charged with his murder. For the rest of us, and I am assuming that you're with me on this one, being on trial for murder would be the worst thing in our entire world. But for Lori, it's kind of like a big field trip. It's like a fresh break from her very boring life sentence, no parole in Idaho. She also has a chance to show off to the world that she knows a thing or two about the law. You know, like having been tried for 3 murders before, being tried for this 4th one. And today things kicked off in earnest in Arizona. The prosecutor, as is normal, spoke for the people, and Lori Vallow spoke for Lori Vallow as her own attorney. And if that's a big surprise, it should be, because this is the same woman who was not even competent to stand trial months ago, let alone defend herself. But here we are with Lori Vallow parading around the courtroom, making blunder after blunder right out of the gate. If you did not have time to catch her entire performance, I've got your back. Here is her attempt at an opening statement. And please keep in mind, trials can be won or lost during opening statements. So you have to tell the best story you can put together for the jury. But in what could be considered a drinking game, count the number of times that Lori says the words, "The evidence will show."
The evidence will show that on the morning of July 11th, that Tylee was asleep in her room and my brother Alex was asleep in the guest room. The evidence will show that when Charles entered the house, only JJ and I were awake and present. The evidence will show that after we put JJ in the rental car, that Charles came back into the residence to receive his phone, leaving JJ in the front seat of the rental car with the engine running. He was 7 years old. The evidence will show that Charles began to scream at me when I refused to hand him his phone. The evidence will show that Charles' screaming woke up Tylee and Alex. The evidence will show that Tylee came out of her room with a bat to protect me, her mother, from her stepfather, Charles Vallow. The evidence will show that Tylee and Charles fought over the bat, and that after a struggle over the bat, Tylee fell onto the ground. And Charles lifted up the bat to hit Tylee with the bat. The evidence will show that Alex then intervened to protect Tylee from being hit with the bat. The evidence will show that after this struggle on the ground between Charles and Alex, that Charles prevailed with the bat and began to come towards me with the bat as I ran away from him into the kitchen. The evidence will show that at some point while I was running away from Charles, who was chasing me with the bat, that Alex apparently retrieved his gun. The evidence will show that Tylee and I got into the rental car with JJ and drove away. The evidence will show you that I drove the children away from the residence towards JJ's school. Can I grab a tissue?
Yes.
The evidence will show that the last thing I heard from Chandler Police Department until June of 2021, 2 years later, when I received a grand jury indictment from them for this alleged crime. The evidence will show that Chandler Police treated this incident as self-defense.
And object to that?
The objection sustained. The jury should disregard that last statement.
Yeah, that was not the only objection that Lori faced in court today. By the way, there's no crying and lawyering. You're not allowed to cry if you're going to be your own lawyer. You got to be a lawyer, or you can be the defendant crying, but you can't do that. She did it anyway. So in her cross-examinations, Lori really seemed to struggle. She had a real blind spot when it came to the rules of hearsay, which is literally things that other people say that are overheard. right? These are things that are generally not allowed in a courtroom. There are exceptions, but it's tricky. Any first-year law student would know that. And the prosecutor and the judge both seemed exhausted that Lori did not.
When you talked to the two detectives in the front yard and gave them your synopsis of what had happened, you said they got into a domestic fight consistent...
Objection.
I'm sorry.
I'm going to sustain the objection.
What was the legal objection?
Hearsay.
Hearsay.
Oh, I was just reading his report. Okay.
Then objection, no question.
Please ask your next question.
You said in your report that at one point Alex's niece grabbed the bat.
Objection.
Hold on.
Hearsay.
That's
Improper
hearsay.
question.
Okay, you can't ask hearsay.
Did Alex tell you that he got hit in the head with the bat?
Objection, Your Honor. Hearsay prior ruling.
Yeah, it's sustained. You can't ask questions of what Alex said.
But they were trying to come up to me to find out what was happening.
Objection,
Okay.
speculation, hearsay.
I'll sustain the objection. Let's take our afternoon break for the staff and the jurors. We're going to take a 15-minute stretch restroom break. Please remember the admonition.
Lawyering is hard. It's really hard. It is not what it looks like on TV. This is where I stop and I bring in Lindsay Holler. She is the producer of my podcast, Drop Dead Serious. She is live on location. She's been in that courtroom all day today. Lindsay, look, we just showed some highlights / lowlights, but overall, you got the full picture of Lori's performance. How would you grade it? How'd she do?
Well, you know, she did seem like she did a little bit of homework, but the problem is that, you know, she's the defendant and part of her, and she's also her own lawyer, so she's trying to tell her own story, but the problem is that Lori's story doesn't compute with the evidence that's going to come out. And so, you know, as much as she wanted to appear composed and calm, you could see she was getting visibly frustrated, and especially when she would get objected to. You know, why? You can't ask that.
Right, so that's the thing I wanted to say, because a lot of times the camera position is like this. We can either see the side of her face or the back of her head, but during those objections, I saw none of her face at all. I'm not sure if you had a position where you could see, but what was her, like, did she look as though she recognized she'd made a mistake, or did she honestly just not understand what was going on in that courtroom?
I think both. There were times where she seemed like she understood, when, oh, I'm sorry, you know, little mistake, but then other times where I think she legitimately didn't know what she was doing, and you could tell. And I did have a close seat. I could see everything, and I mean, especially during opening statements when the prosecutor was saying things she obviously didn't like. She was angry. She looked furious.
Well, you know, I'd seen the report that she was rolling her eyes and shaking her head. So walk me through that a little bit. Give me your eagle-eye perspective, because, again, we get the back of her head. So she was. I actually was kind of on the right side of her, so I could see, you know, she would shake her head and kind of, you know, look down, scribble furiously onto her legal pad at one point when the prosecutor said that the jury was going to hear that she was crushing up JJ's pills to drug Charles. She flipped her legal pad, her yellow legal pad, over and slammed it. And I'm not sure if the court audio picked that up, but it was really loud in court. And, you know, if the jury sees that, they see her demeanor, they're going to start wondering what's going on. Why is she making faces during the prosecutor's opening statement? Not only that,
it was something, it was remarkable.
If you're a lawyer doing that, you would be held in contempt of court. You might get a warning, maybe a second warning, but you'd be held in contempt of court. At any point did the judge take her aside? At any point did the judge say something publicly like, Ms. Vallow Daybell, you're going to have to stop that behavior? And I can't imagine he would say that to her in the presence of the jury, but at any point did anyone counsel her, grow up?
No, they didn't. And I'm wondering, we're going to get to a point where he's going to have to do that, because this is just opening statements. You know, you could tell she was trying to appear calm, trying to be on her best behavior, but she just couldn't let herself do that. She couldn't control herself. I mean,
she also
like she
doesn't
always-
understand
like she always is.
that's not what lawyers do. Yeah, like she always is. I could see with her interview with
Right.
Keith Morrison how histrionic
Yeah.
she was,
Yeah,
repeating his
exactly.
name over and over.
Yes, and
One
those
last
were the
quick question.
faces. Yeah.
Those were the same ones that you got in the Keith interview. Okay, one last really quick question. We lost a juror today. Is it a big deal, a serious deal? Can you just sum it up in like 20 seconds? What happened with the juror?
Yeah, so the juror's employer actually sent in a note to the judge that, you know, the employer had a problem with him having jury service. The judge questioned the juror a little bit about this at the lunch break, and the juror basically said that he didn't know much about jury duty, and when he agreed, he didn't know that, you know, he wouldn't get paid, and he had child support and alimony, and this would really be a financial hardship on him. So ultimately, he was dismissed. The prosecution seemed a little bit more worried about it than Lori, obviously, because she's not worried about much. But I think they were frustrated to lose a juror on day one, for sure.
Oh, I mean, losing a juror on day one, that is really, I don't think I've ever seen that happen, but it does happen. I get it. Lindsay, thank you so much. I really appreciate all the notes from court today. Really, really good to have you in there with the eyes and ears. And we'll talk to you again soon. Thanks for this.
Thanks, Ash.
Okay, I am joined now by Megan Connor. Megan is Lori Vallow's cousin and was also in the courtroom today, and she happens to host the podcast called The Midlife Revolution. Megan, thank you so much for being with me. First, when I heard that you were in court, I had to do a mental calculation because I have heard that there is not one member of Lori Vallow's family or any supporters there for her. And then when I heard you were there, I still sort of thought she doesn't have any supporters. Am I right? You're not there for her? You're there as a witness?
No, I mean, if I can quote Hamilton, I'm not here for you. Definitely not there to support Lori. I'm there to learn the truth of what happened. And I'm there to get some measure of closure in my own, all the questions that I have in my mind of what happened in the days leading up to Charles's death and afterwards, how the Cox family behaved and who was involved and at what level.
Yeah, I can understand that. And my choice of words was wrong when I said a witness. I meant you wanted to see what was happening. You're not actually a witness going to, take the stand in the case. But I wanted to ask you if the Lori that you saw today, because listen, you're a family member. We're really just seeing her speaking for the first time. She was silent during her trial. We saw her sit there, really, and she didn't take the stand. So this is very eye-opening to see this personality popping out. Is this the same Lori that you know, that you and your family grew up with, or is this someone you don't recognize?
Well, there's definitely an aspect to Lori that has changed over the last years. Her histrionic style, her religious zealotry, her delusion, those are things that have changed. But the tactics that she uses to try and get her way, to try and manipulate, to try and get what she wants, those are the same things that I personally have seen historically. And I know not all my family members agree with me about that, but my personal experiences with Lori, very much the same. You know, her fake crying today, I believe it was fake. And her basically trying to endear herself to witnesses and to jurors by sort of making jokes, pretending to laugh along. You know, she was really trying hard to get people on her side. And that's kind of the Lori I've always seen. However, in a courtroom setting, she has rules and she can't use the same tactics that have worked for her before. And I think that's really frustrating to her.
I can imagine. And you know what? The rules are tricky. Even for people who know the law, it's very hard to navigate criminal procedure in that courtroom. And I'm about to ask someone who's an expert in this exactly how tricky it is and why, even when you know what you're doing, you don't know what you're doing. But I do need to ask you this. The rest of your family, how do they feel about you being there, and how do they feel about what's happening in this courtroom?
Well, I do want to point out that my uncle Rex was there today. This is Lori's uncle also, and he was there with three of his daughters. They came to some of Lori's previous trial. I think it's important to them to see some of the evidence in this case. They've all lived close to each other for a long time. I will just say I have a different perspective from a lot of my family members because I've distanced myself from this particular part of the family, the Cox part of the family, for a long time. And I also am no longer a part of the LDS Church. And so my perspective from the outside is very different than the perspective of a lot of my family members. I've also been through a great deal of therapy and healing. And so I have a hair trigger for manipulation and control. I recognize those tactics like right off the bat. And for other family members, it's a little bit harder for them to accept that this is the way that Lori has always been.
Megan, I'm really appreciative of you being on the show and being so candid. And I'm very sorry that you and your family are going through this as well. This can't be easy for any of you. So I hope I can speak with you again as this progresses.
Of course. I'm always happy to come on your show. I enjoy your show and I enjoy your podcast. So I'm happy to do it.
Oh, I appreciate that. You know what? For that, I'm going to just do the quick plug again. Megan Connor's podcast is called The Midlife Revolution. Thank you, Megan. I appreciate it.
Thanks, Ashleigh.
I want to turn now to a defense attorney who, unlike Lori, actually has a law degree and thousands of hours of practice. It's Mark Eiglarsh, friend of the show, friend of mine. It's not easy, is it? It's not like it looks like on Suits. It's not like it looks like on LA Law. Criminal procedure, on your feet, in a courtroom, litigating is hard.
Yes. So let's start with something I agree with you. It is difficult and it should be left for those who went to law school. That said, Ashleigh, I don't come on your show to disagree with you. I just find myself doing so every now and then. First, yes, she should have had her own lawyer. Secondly, she did a horrible job on cross-examination. Third, if she said, the evidence will show one more time, I was going to wring her neck metaphorically. That said, I'm giving her a B, as in boy, minus on her opening statement. She was passionate. And by the way, I'm no fan of the murderer. She was connecting with what she was saying. She took her time. When she was describing the important details of what occurred, you almost felt like you were there, that this looked like self-defense. Obviously, it's all hogwash, but all it takes is one juror to believe in what she's saying. And every time the prosecution objects, every time the judge shuts her down, they could feel for her, like she's doing the best she can, and these smarty pants lawyers are shutting her down.
You know, let me ask you this, Mark, because we've talked about the blunders, we've talked about the complete, inability to understand hearsay. This is going to keep happening, and it's going to be very frustrating for these jurors that the judge is going to have to continue schooling her like this. And eventually, the judge may not want to school her anymore. I am more concerned, though, with if and when her triple murder conviction comes into the case. People hear about prior bad acts all the time. They're not always allowed in. Those are going to make their way in. It's a question of how and when.
Yeah, well, if it does, again, I don't know that the judge ruled that that's admissible. Is that your understanding? Because if so, that would grossly prejudice this jury. They hear that, they're done. If that does come into this case, which I don't believe it should because it's so more prejudicial than probative. And again, you wanted to get a fair trial. You don't want to do this twice. I don't think it should come in. If it does, she is done.
Well, I think it's going to come in because I think she is going to take the stand because she is literally on the stand almost in, demonstrative ways in this courtroom. But let's have this conversation again because this is something I just don't know how or when it's going to happen. But she's so terrible at understanding criminal procedure, she's going to open a door. I believe she will inadvertently open a door because even great lawyers open a door by mistake and then all that stuff floods in. Will you come back when if that happens, when that happens?
I will. And on that last point, I do agree with you.
Oh, my gosh. Can we just make sure that's on tape? This is on tape, right? Mark Eiglarsh just agreed with me. I've waited my whole career for that. Thank you, Mark. Appreciate it. Thanks for watching. Go to joinnn.com to find NewsNation on your screen. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.